2 years ago, we, meaning America and the world, were deep in the throes of what has now become known as the Great Recession. It's perhaps the most traumatic economic period for Americans since the Great Depression. Retirees saw the value of their 401k plans reduced by as much as half. Unemployment rose above 10%. Great companies went bankrupt, and entire sectors of the economy collapsed. While there are many theories as to what caused these events, key among them are concerns that institutions, financial institutions, led by America's best and brightest, but thought too big to fail. And we've learned that's how we treat them. We're either ignorant and stupid, not recognizing the risks that they were taking, or because of safety nets provided by the government or other sources, we're willing to take risks that were unfortunately overwhelming and should not have been taken, knowing that we, the taxpayers, would bail them out. Our panelists will be exploring 3 distinct topics related to structural problems relating to the recent recession and the causes of it. 2 of our speakers will be discussing questions about how to manage, or perhaps how not to manage, financial institution risk, especially for those considered too big to fail. Professor Coffey will be talking about an idea on how to mitigate systemic risk associated with financial institutions by requiring a new layer of contingent debt, contingent equity rather, debt that converts to equity, to create a class of holders who can pressure management to avoid risk or mitigate risk. Dean Mahoney will discuss the extent to which recently adopted provisions of the Dodd-Frank bill actually cures too big to fail, or perhaps it might actually exacerbate the problems of too big to fail. We'll also hear from both Professor Coffey and Professor Jones on issues about how regulators fall down on the job, sometimes because of systemic issues relating to how the regulators are organized or who they can talk to. Our format will be that each speaker will have 20 minutes to speak. We will then have a discussion amongst the panel, a brief discussion, and then open it up for questions. I will introduce each speaker before they speak, rather than going through all 3 biographies now. So I'm going to introduce our first speaker, Professor John C. Coffey, Jr., the Adolph Burrell Professor of Law at Columbia University, befitting one who holds that chair, named for the legendary father of the corporate governance studies that we all read if we work in corporate governance. Professor Coffey is a prolific writer and commentator and is one of the most recognized authorities in the corporate bar. After graduating from Amherst College and Yale Law School, he went into academia after 6 years at Cravath, Swaine and Moore. So he had a lot of experience in practice before he went into academia. While he was practicing, he got an LLM in taxation from NYU. He then joined the faculty at Georgetown for 4 years before taking up his post at Columbia. He's been a visiting law professor at Harvard, Stanford, University of Virginia, and the University of Michigan. Rather than reading a list of his other accomplishments, I will simply tell you that if you do a Google search of Professor Coffey, his unique name, you will find over 440,000 hits, which is a pretty marvelous number for a person who's not an athlete, not an actor.
Not an athlete.
And, well,
professional.
We'll put him right up there with his beloved New York Yankees. And not a politician either.
That's for sure.
Second, I've got to tell you as a retired practitioner that his works are widely regarded as must-read materials by practitioners, legislators, and judges who, as someone who's only creeping into the world of academia, still believes are the people who count. So with that, do you want to stay where you are?
I got to move the slides.
Oh, you've got to move the slides.
For those of an age that resembles mine, you don't need to be told who the man in the lower right is, but for students, I should point out that this is the Monopoly man, and he came from something called the Monopoly game, which you gave younger persons to play with on rainy days to keep them out of trouble. Unfortunately, that board game had insufficient gratuitous sex and violence to become an electronic game, and thus no one knows who this is anymore. But he's my symbol of the bailout. What the bail-in is, we'll come to in a moment. Here's what I'm going to address, and you may say this has little to do with securities law. This is partly so that I don't have to insult anyone at the SEC who are present today, but I think these are the biggest issues out there. Before we can worry about the fiduciary duty of brokers, we have to make sure the financial system doesn't crumble again, and that requires addressing systemic risk. So there are three huge questions that I'm going to just acknowledge at the outset. What caused the 2008 financial crisis? Can it happen again? Where does the Dodd-Frank Act leave us? I think that we could spend the next 2 hours talking about what caused the 2008 meltdown. It's one of my favorite topics, but I want to focus on the academic discussion, which is largely focused on the very popular claim, most notably made by Lucian Bebchuk, that executive compensation formulas caused financial executives to take on excessive risk and leverage. I think that claim overlooks the strong possibility that shareholders may have very willingly contracted for very lucrative financial compensation and stock option compensation with managers to induce the latter to be less risk averse and to take on greater leverage and risk. Put very simply, shareholders and managers have deeply conflicting interests. Shareholders are diversified, managers are not. And thus there's a school of scholarship led by Michael Jensen that says naturally managers want to retain free cash flow in the firm and not pay it out, and shareholders have to induce them through mechanisms such as executive compensation to pass out that free cash flow. Now that makes a lot of sense in the context of the normal industrial corporation. But when you start talking about banks and other shadow banks, one of my basic points is banks are different. Banks produce a risk of externalities and major financial collapses because they are essentially too interconnected to fail. And there, we have to worry about whether we are letting shareholders give excessive incentives to managers to take on leverage and risk. So shareholder pressure for increased risk and leverage is a problem that very much survives Dodd-Frank. And for example, rules like SEC's Rule 14A11, the proxy access rule. While it may be a very sound idea for the ordinary world of corporate governance, may be a little bit more dangerous when we come to financial institutions. I'm not sure I want Carl Icahn on the board of Citicorp pushing for more risk and more leverage. Certainly I think that counteracts everything we're trying to do through greater investment in the Dodd-Frank Act, in oversight and regulatory controls. That's my basic view on the first question. Can it happen again? Absolutely. We can have 2008 again because of the inherent fragility of financial institutions, and I'll return to that, because of the political economy of financial regulation, and the key fact that the easiest way to increase the profitability of a financial institution is to increase its leverage, and thus there'll be a long-term tension between regulators and financial institutions over issues of risk and leverage. And lastly, for a reason that I will defer and give Don Langevort the chance to discuss, because it's one of his favorite topics, bounded rationality, the limited cognitive capacity to react and respond to new risks, and new risks will always sneak under the radar screen and be detected by regulators only after they are getting to be serious problems, at which point the regulator is usually trying to deny it's a serious problem to avert any sense of panic in the market. All right, now, lastly, where does the Dodd-Frank leave us? Now, here I'm going to say something a little heretical. In the name of preventing bailouts, which was a political necessity in the adoption of the Dodd-Frank Act, the Dodd-Frank Act may impose a straitjacket on financial regulators, denying them their traditional powers to advance funds to solvent firms in a liquidity crisis. Although Dodd-Frank permits the insolvent firm to be liquidated and authorizes the FDIC, pursuant to its new resolution authority, to issue guarantees and advance funds incident to this liquidation process, which is really a death sentence. Neither the Fed nor the FDIC can advance funds on a targeted basis to solvent but vulnerable financial institutions that are on the precipice of a collapse, that are in that zone of liquidity crisis. And that is a danger. In fact, what I'm going to say basically is that U.S. financial regulation after Dodd-Frank may have painted itself, or Congress may have painted it, into the proverbial corner. Let me raise a name that isn't mentioned every day anymore, but the first real student of central banking was Walter Bazio, who wrote a classic book called Lombard Street in 1873, not yesterday, but it explained what central bankers really did. And he announced a policy that central bankers really followed for the next century and a quarter. That is, that the critical role of a central banker facing a liquidity crisis or financial collapse was to quickly distinguish those firms, those banks that were only facing a liquidity crisis versus those banks that were truly insolvent. And the policy for 100 years was make sure you get money quickly to those that are only facing a liquidity crisis, but shut down those that are insolvent and figure out which is which as fast as you can. Dodd-Frank stands this rule on its head. Little or nothing can be done to the solvent firm facing a panic because the statute very carefully takes all power away from the Federal Reserve to advance funds on a targeted basis. It can only make a general facility open to the world, and it must get fully adequate collateral because Dodd-Frank was driven by the political toxicity of further bailouts, okay? The insolvent firm can get all kinds of credit, but it's part of this gradual liquidation and shutdown. The result may be believed, particularly shadow banks, and by shadow banks, I mean all your old friends from 2008, Lehman, Bear Stearns, AIG, and any other institution that is not a classic depository bank. It may leave them stranded on the precipice of failure, unable to get any kind of assistance from the federal government, and exposed to a panic. And that can have a very large destabilizing effect, both in the U.S. and internationally on a global level. Therefore, I'm suggesting we need an alternative, and I'll get to that shortly, to deal with the troubled but not insolvent financial institution. Okay? Let's go back to this problem of shareholder pressure. Shareholders, of course, rationally pursue wealth maximization, and they rationally give less attention than editorialists and commentators and academics tell them they should give to the externalities that wealth maximization can sometimes produce. Just like pollution, systemic risk can be viewed as an externality that shareholders may underweigh. Again, because the fastest way to increase the profitability of a financial institution is to increase its leverage, we can expect for the future a continuing tension between regulators and financial institutions who, prodded by shareholders, will seek ways to quietly increase their leverage in various ways that are generally off the balance sheet. And again, shareholders can induce management to do this through executive compensation. Now, the empirical evidence, which I go through at great length in my paper, but I don't think it presents that well here, is in some conflict. Lucian Bebchuk has a number of papers in which he says managers got extreme compensation, and that gave them a short-term focus. He may well be quite right, but why did they get that compensation? I don't think the answer is they took it, they stole it, they misappropriated it. I think the answer is, which has been suggested by Renee Stoltz, that shareholders contracted with them in order to induce them to take greater risk. And what Renee Stoltz finds out in a worldwide survey of all banks in the 2008 period, worldwide banks whose CEOs were better aligned with the shareholders through stock options and other kinds of bonus incentives actually performed much worse in 2008. The better your incentives were aligned, the more you were on a financial roller coaster that peaked in the boom times and really collapsed in the bad times. Banks that the market favored in 2006 had especially poor returns and neared insolvency in 2008, and vice versa. The firms that the market liked least in 2006 because they were stodgy and conservative did very well in 2008. There's a series of other scholars that have made the same finding, that shareholder-friendly banks do well in booms but very badly in crises. And again, Rule 14a11, as applied to major banks, will arm activist shareholders with a new weapon by which to pressure for higher leverage. The bottom line, the more shareholder-friendly the financial institution, the greater the exposure to insolvency in a crisis, and the greater risk we have of a return to 2008 if things turn sour again. Next point, the predictability of systemic failure. Dodd-Frank did not outlaw systemic failure. It can return. The Dodd-Frank Act invests very heavily in prevention, regulatory controls, and monitoring. I applaud all that. but I also recognize its limits. Systemic crises may still reoccur because of inherent bank fragility, because of what I call the regulatory sine curve, and because of cognitive limitations. Bank fragility, we have to always recognize that banks are different. Banks and shadow banks face a fundamental mismatch between the short-term character of their liabilities and the long-term character of their assets. That's what's always caused bank runs, all right? Shadow banks are not dissimilar. Although they don't have depositors, they tend to finance themselves through repos, commercial paper, and similar short-term notes. In my career, I can remember when Drexel Burnham went downhill because it couldn't roll over its commercial paper in a panic. And both Lehman and Bear Stearns went through that same process where their short-term creditors would not roll over the repos. So there is this problem of a mismatch and an inherent exposure to a run. And now that they are interconnected, and Gary Gorton makes this point in a recent book, panics now attack the financial system as a whole rather than just individual banks on a retail basis. As to the regulatory sine curve, we have to recognize that regulatory intensity is not constant, not uniform, but it tends to relax as the crisis atmosphere fades and normalcy or alleged normalcy returns. This is the exposure of less political pressure on the regulator. It's also the product of lobbying pressure. It's been estimated that just the New York financial institutions spent something like $800 million between 2008 and 2010 lobbying Dodd-Frank, and that same money will be expended on lobbying the regulatory process that we'll see over the next 18 months and thereafter for the rules implementing Dodd-Frank. And then there's regulatory arbitrage. Throughout the 90s, when there may have been some relaxation in U.S. controls, there was always the argument that the U.S. was losing its competitive advantage to London, which had regulation light touch regulation, and a general aversion to enforcement. Well, London may have learned this lesson too, but there always will be some other part of the world in which major economies, maybe Singapore, maybe Hong Kong, have lighter regulation. And there'll be the argument that unless we meet them and relax our regulation, we will lose our competitiveness. So there is always going to be this tension between regulators and the industry, and the sine curve will go down. The cognitive limitation story, again, I leave this to Don, who is the master of this story. The AIG story confirms this. It had massive internal controls. It had all kinds of limitations on its executive compensation, but it simply didn't understand what would happen to it if there were regulatory downgrades and the amount of margin calls it could suddenly become subject to. All right, so there are limits to preventive oversight. I applaud Basel III. I applaud capital adequacy regulation. But it works only to the extent that banks cannot hide their liabilities off the balance sheet. Because if you hide your liabilities, capital ratios based on the balance sheet don't work. And 2008 revealed that banks can be very creative, very innovative in the ways they can hide their liabilities off the balance sheet. Liquidity puts, SIVs, which are structured investment vehicles. And I have to predict that innovation will continue. Banks will continue to creatively find ways to hide some of their liabilities. And once the problem develops, regulators are always constrained because they don't want to announce that there is cause for concern. What would work to mitigate systemic risk? I think that there are two options globally. I endorse both of them, but the first is probably not politically feasible in the United States. The first is a mandatory industry-funded private bailout fund. This is what the International Monetary Fund has been pushing for a couple of years now, and they would want a bank tax imposed that would fund a fund over time equal to something between 3 and 4% of the gross domestic product of all of the countries participating. That's a multi-trillion-dollar fund, not something that will lightly go through the U.S. Congress. Now, this kind of approach is favored by those who see the root problem being that banks are too big to fail, and therefore banks can get capital too cheaply. They don't pay the full interest rate they should pay because the creditor says the government won't let them fail, so we'll give them capital at too low a price. That's a subsidy, and if you believe it's a subsidy, you want to offset it by a bank tax that removes that subsidy and forces them to bear the true cost of their risky activities. That's probably part of the story, and I think I do support the general idea, but they're focused only on the creditor giving capital too cheaply. And I'm focused on another portion of the problem, which is shareholder pressure to increase risk and leverage, and I think that will continue to exist even if we had the bank tax. But we won't have the bank tax in the U.S. because it was originally in both the House and the Senate bills in Dodd-Frank. The Senate bill had a $500 billion private bailout fund that the industry had to fund, that it was taken out. It sounded too much like a bailout, and the Democrats couldn't resist the pressure they were getting, and they withdrew it because this would become a major political issue. That was in the House bill, and the Senate bill also took out a much smaller one. I think we found that it's not politically feasible in the U.S. in the short term. What then is the alternative? And now I get to contingent capital. Contingent capital is debt that at one or more predefined trigger points automatically converts into an equity security so that the debt security cannot default and cannot cause a bankruptcy. Now, is this a pie-in-the-sky reform? No, because this is authority that the Fed has today. The Dodd-Frank Act does authorize the Federal Reserve to adopt a contingent capital standard for systemically significant financial institutions, for the really big banks that could be too big to fail. The Fed could thus mandate that a defined percentage of a bank's capital would have to consist of a debt security that would convert into an equity security, thereby subordinating it to the short-term debt. And it's the short-term debt that is usually the flashpoint. That's where the crisis occurs, when they suddenly, in the short term, back away because they panic. That's Lehman, that's Drexel Burnham, and that was also Bear Stearns. Now, here comes the interesting question. People have just said, well, we ought to have something that converts into equity. I don't think they focused adequately on the design of contingent capital. The use of contingent capital has now been endorsed by everyone in Europe. The Association for Financial Markets in Europe, the Squam Lake Working Group in the United States, Canada's bank regulator, and 2 weeks ago a Swiss commission recommended, and this could well become Swiss law very quickly, that Swiss banks have to hold capital equivalent to 19% of their risk-weighted assets, but 9 of this 19% could be contingent capital, making this much more attractive than having 19% equity, having this contingent debt security. So we may see attempts to sell it. Now, all of these proposals contemplate a debt security that converts into common stock. Such stock would quickly trade and would wind up being held by the usual institutional investors, and that does nothing to reduce shareholder pressure once it becomes equity. And here I want to return those corporate law people in the room to the old problem of the vicinity of insolvency, which Chancellor Allen described rather elegantly in his Credit Lyonnais decision, that once we get into the world of near bankruptcy, the vicinity of insolvency, common shareholders have perverse incentives. It is rational in that context to take the company's last $1 million and buy an Irish sweepstake ticket with it, because that's the only way you can possibly get a payoff that will they'll pay you the $100 million that you need to pay off your debt holders when that debt becomes due in another month. So you take extreme long-shot risks as a common shareholder when you are in the last stages of approaching insolvency. That's part of the problem of having equity and control of the firm as we approach the vicinity of insolvency. My proposal, therefore, would convert the debt security at a series of incremental stages with stage triggers into a voting preferred stock with a fixed limited return and with cumulative dividends. The holders of such a fixed return senior security would have rational incentives to oppose risk-taking and higher leverage. They would have the same incentives as the bondholders. They would be against any acceptance of further risk after their security converts into a voting preferred stock. The goal here, which I think a goal you have to face in designing this kind of security, is whether or not to use the voting rights for a meaningful purpose. And I want to use the voting rights, in addition to the capital structure changes, to create a countervailing voting constituency to the common stock, and thus to create a buffer that insulates the bank's management from shareholder pressure in this area of near insolvency or at least financial strain. Okay, how would it work? And again, I'm going to give this very quickly. Assume the Fed were to require a significant financial institution to issue contingent capital in amounts equal to roughly their short-term debt, probably not less than half of their overall long-term debt. You would probably use a double trigger. That is, on a decline in the firm's stock of some amount, let's say 25%, and a decline of not less than another percentage in a stock index for the financial sector. Thus, we are not dealing with a flash crash or a general market decline. We're dealing with a special decline of the financial sector and a particular decline of this stock. Then a percentage, maybe 25% of the contingent debt, would convert into the voting cumulative preferred. The dividend rate would be set to hold the debt holder no worse off. That is, if he was getting 8% as a debt security, he might get 11% as a preferred stock security, so that the cost falls on the shareholder and not the debt holder when there is this conversion. Now, subsequent conversions might occur on a number of other steps. You could have a further stock decline. You could have a defined ratings downgrade by NRSRO rating agencies. You could also use an increase in the spreads on credit default swaps. Those are all second steps. There are problems with each of these steps that I go through, or will go through more in the full paper, but the idea is to have incremental conversions so that this voting block gets larger and larger as we get closer to this zone of insolvency. We're using this trigger because we have to have an early trigger. Corporate governance is not going to work if we convert only at 11:55, 5 minutes to midnight. That's too late. We've got to have a new block in there that will be pushing management from the opposite side, not to increase risk, not to take greater leverage. And to protect this preferred class, they would get not only general voting rights, but they would get a special right to elect additional directors each year that their dividend is not paid. That's the normal provision, by the way, for preferred stock when accrued dividends are not paid. But it would mean that the entire control of the company could go over to the preferred if their accrued dividend is not paid. What are the objections? And I'll be quick here. The first objection is it will not sell. There actually have been 2 successful offerings of contingent capital this year in London, Lloyds Bank and Rabobank. They're very different companies. One was troubled, one was AAA, but they were able to sell this. Not easily, but they did sell it. Moreover, I think debt convertible into a senior preferred stock is easier to sell than debt convertible into a common stock because, frankly, many institutions can't hold common stock, but they can hold or rationalize holding a senior security. Also, they're protected against, no one wants to hold a common stock of a collapsing bank. You'd rather hold a preferred stock with an increase in the dividend rate to offset and hold you constant. I think there are a lot of pricing adjustments here that could make the security attractive, if costly. Yes, it would be costly, but this is a cost that's spent to avert insolvency. Next problem, rating agencies will not rate it. To date, they've been reluctant, but I think this is going to change. Regulatory encouragement is coming in Europe to them, and this would be an entire new major asset class, and they can't afford to take themselves out of that market and not rate convertible securities if it's a major asset class. Next question, why don't we just issue the preferred stock at the outset? Well, that's the same thing as giving voting rights to bondholders. I don't think you want to give voting rights to fixed interest claimants generally. Voting rights generally belong with the residual risk bearer. We're only doing this at a transitional moment when the company gets nearer the zone of insolvency, and then we are giving voting rights to this constituency in order to create countervailing pressure on the management so they're not simply the subject of risk-preferring common shareholders. Conclusion, this is meant as a fail-safe remedy, not as a panacea, not as a complete remedy, but it assumes that regulators, after all, are fallible. They will sometimes miss problems that fly beneath their radar screens. Accounting and regulatory requirements can often be outflanked, as they probably will be with Basel III once again, and the market stock price or credit default spreads are probably the most objective and relatively unbiased judge of the company's performance. Using a voting preferred stock changes contingent capital, so it's not simply just a way of avoiding default, but it's also a way of creating an offsetting constituency that will resist shareholder pressure for risk. This is a remedy that can be implemented today, which we can't say about many other remedies. And finally, my last sentence, the future of securities regulation, which this conference is about, I don't think it can be fully assessed without addressing the still looming problem of systemic risk. Okay, thank you.
Well, our next speaker is Professor Renee Jones, who comes to us from Boston College. She is a graduate of Princeton University. Our dean had some connection with that school, so that's always special for him. And from Harvard Law School. She worked for 8 years at the Boston firm of Hill and Barlow, where she represented public and private companies on corporate and securities matters. She joined the BC faculty in 2002, where she teaches corporations, corporate governance, and securities regulation. Her scholarship focuses on corporate governance, but also on corporate ethics and the federal-state relationship in corporate regulation. In that context, she's written several important articles on corporate federalism, a topic I know is of interest to Professor Dent here, as well as to me in my continuing role helping to write Ohio corporate law. Professor Jones is a member of the American Law Institute, as well as a number of other organizations, and her topic focused on the revolving door between the regulators at the SEC and the private defense bar should be of high interest to all of us, but particularly to someone who is at a firm which has a strong white-collar crime unit. Professor Jones?
Thank you. I'd like to start by thanking George Dent and the Center for Business Law and Regulation and the staff for organizing this conference. I'm really happy to be here, and I'm looking forward to an interesting day. As Professor Porter mentioned, my remarks will focus on the common claim that the SEC's recent failures to vigorously police fraud can be attributed, at least in part, to the cozy relationship that exists between the SEC enforcement staff and their lawyers who regularly represent the large financial firms. Many commentators have observed that the SEC has lagged behind state regulators, academics, and the press in uncovering some of the past decade's most spectacular frauds, from analyst conflicts and market timing to options backdating, and even to Bernard Madoff's massive Ponzi scheme. So the typical career path for SEC attorneys usually includes a term at the SEC followed by a lucrative practice at a Wall Street firm, and this common employment pattern feeds perceptions that clients of former SEC staff receive favorable treatments in matters before the agency. This is a loaded charge, I think, with significant implications, and I think it deserves more careful examination than it's received to date. So I'll want to make a caveat that I'm mindful that we have many distinguished SEC staffers and alumni among our panelists, and I want to make clear that I'm working in my research with the assumption that most of the SEC staff are honest public servants and that they're devoted to the agency's mission. And I'm also assuming that outside attorneys who, while they're working as zealous advocates for their clients, don't view their conduct as unfairly interfering with the SEC's work. But my analysis does suggest that even though most participants in the system believe they're doing what's right, there's a pattern of interaction that's evolved that seems to have had a corrosive effect on the agency's enforcement mission. So let me first summarize what are the common perceptions related to the revolving door's impact, and then I'll assess how those perceptions comport with reality. So the first common charge is that high-priced attorneys procure special treatment for their clients, including getting the SEC to drop investigations, shifting focus away from their clients to other possible targets, and obtaining favorable settlements on favorable terms with no penalties or minor penalties, despite sometimes damaging facts. And related to this perception is that enforcement attorneys are more lenient with powerful industry players and their lawyers because they hope to someday work at these very firms. That is, the thought is that by being cooperative with lawyers in private practice, they can develop contacts which will help them land lucrative positions in the future. And finally, some maintain that this preferential treatment has led to a two-tiered system of justice. That is, there's one set of rules for large firms and key players in the industry, and a second set of rules for everyone else. So these types of observations appear regularly in academic literature. They appear regularly in the press, but I think there's surprisingly little sustained analysis of the precise nature of the problem, or even whether the problem exists at all. So let's explore the reality. First, I think there's empirical evidence which suggests that there's something to the charge that large firms fare better in enforcement actions than smaller firms and individuals who are located outside of the large financial centers. Studies by Stavros Garinas and Randall Thomas and Jim Cox reach conclusions that are consistent with this thesis. And although there are a number of plausible explanations for this result, the most obvious, I think, is that the large firms can afford better lawyering and get better results. Still, many fear that there's something more insidious at work, and they look to capture theories for explanations. So in addition to this empirical evidence, there's also anecdotal evidence that can be gleaned from recent investigative reports that suggest that there's a special access system at the SEC that favors high-profile attorneys and former staffers. And these inquiries reveal that informal communications with outside attorneys on pending matters can lead to irregularities investigations, meaning there are unexplained departures from the normal course of conduct or an unusual degree of interference by senior officials in the staff's investigative work. So the most widely reported inquiries into this revolving door problem are the investigations by Congress and the SEC Inspector General into the termination of Gary Aguirre, who was a former enforcement attorney. And these investigations concluded that Aguirre was fired for complaining about what he perceived as his superiors' preferential treatment for John Mack, a Wall Street CEO. So I'm sure many of you are familiar with this story, but I want to recount some of the details that shed light on the mechanisms of influence within the division. So Aguirre was handling an insider trading investigation of Pequot Capital, which was the world's largest hedge fund at the time, and the investigation focused on Pequot's trades, suspicious trades in Heller Financial stock and GE stock ahead of an announcement that GE was acquiring Heller. And the trades netted Pequot nearly $20 million in profits. So Aguirre had identified John Mack as a potential source of the information about the Heller deal. Mack was a close friend of Pequot's manager. He was an investor in several of their funds. He was a CEO of Morgan Stanley, which had advised GE on the Heller deal, and he was also interviewing for the CEO position with Heller's advisor on the deal, Credit Suisse First Boston, when Pequot's suspicious trades began. So when Aguirre first identified Mack as a potential tipper, his supervisors were supportive of his theory, but their enthusiasm waned after Morgan Stanley's lawyers contacted the SEC with questions about the status of the investigation. Aguirre first received a phone call from Eric Dinalo, a lawyer from Morgan Stanley, who told Aguirre that Morgan Stanley was considering hiring Mack as its CEO, and he wanted to know whether or not Mack was a target in the Pequot investigation. So, acting consistently with the agency's ethics rules and confidentiality, Aguirre said to Dinalo, "I can't tell you that," and quickly got off the phone, and he reported this conversation to his supervisor, who expressed some concern about the quandary. He was worried that if Morgan Stanley went ahead and hired Mack, and then there was a problem with the SEC, that would somehow affect Morgan Stanley's stock and could disrupt the financial markets. So they consulted the associate director, Paul Berger, who instructed them to say nothing and said that he would call Dinalo himself. And when Berger called Dinalo, according to Dinalo's recollections of the conversation, Berger implied that the SEC did not have any evidence of wrongdoing by Mack. And then a few days later, Mary Jo White, a former U.S. attorney who had been hired by Morgan Stanley to vet Mack, called Linda Thompson, the SEC's director of enforcement. And White asked Thompson to expedite the SEC's review of some subpoenaed documents so that Morgan Stanley could make a quick decision about Mack. And after reviewing some documents that White had sent over, Thompson called White, and according to White's recollection, said that while there was some smoke surrounding Mack, there surely was no fire. So at this point, with two senior officials at the SEC, Berger and Thompson, had made statements to Morgan Stanley's counsel that implied that Mack would not likely be a target of the Pequot investigation, and that the SEC lacked concrete evidence against Mack. And then Morgan Stanley relied on these representations to go ahead and hire Mack. So even though perhaps subconsciously the senior officials had made an implicit commitment that they weren't going to pursue an insider trading case against Mack. So Aguirre alleged that after these conversations, his supervisor's attitude toward the Pequot investigation changed dramatically. His immediate supervisor warned him that getting authorization to subpoena Mack would be difficult because Mack had, quote, powerful political connections, and they refused to authorize a subpoena for Mack, insisting that Aguirre jump through lots of hoops and first prove that Mack had access to inside information before they could bring him in for questioning. So this conflict between Aguirre and his supervisors escalated, and I don't really want to get into it, but eventually they got tired of him. They prepared the groundwork for his termination, and he was fired a few weeks later, just a few days short of the end of his probationary period with the SEC. So this saga is really merely the most detailed account of the ways in which outside attorneys can influence the course and the scope of an SEC investigation. Through these informal contacts, outside attorneys are able to exert influence within the division. High-level access means that prominent attorneys can shape senior officials' views on particular matters, extracting concessions or gaining valuable information that most attorneys don't have access to. And the OIG investigations also reveal the deep suspicion and distrust within the division that these casual patterns of communication can engender. When staff are pulled off cases or told to shift the scope of their investigations, many suspect, whether there's evidence of it or not, that there was a phone call made from a prominent attorney that lies behind the capricious change in strategy. So such suspicions, even if they're unfounded, can have a detrimental impact on morale and agency mission. So I've been thinking about, well, why does this happen? Why do senior officials take these phone calls? Why do they seem to influence the course of investigations? And it seems to me that senior officials act solicitously in these situations in part because they identify with the outside attorney as a senior securities lawyer, and they want to be liked and respected by this person. And it is a sense of identification that leads a senior official to act in a manner that will be perceived as helpful. And so once a senior official has made an informal commitment to take a closer look at the issue, she's likely to make subsequent decisions that are consistent with this commitment. That is, she will tend to view later acquired information in a way that comports with the view that outside counsel helped to shape. And because of this dynamic, outside attorneys can help shape investigations in a manner most favorable to their clients by intervening early at a high level early in an investigation. And the system of special access also seems to lead investigators to pull their punches when dealing with major industry players. The Aguirre report and other similar investigations suggest that enforcement lawyers sometimes tailor their strategies based on their perceptions of who has the ability to pick up the phone and contact senior officials. So when an attorney has such access, perhaps a different set of rules apply. Key decisions are referred to the senior officials, who then try to balance their commitment, of course, to investigatory rigor against a perceived need to get along with their peers outside the agency. So we've seen that large firms tend to fare better with the SEC than their smaller counterparts. And we also have uncovered the existence of a special access system that sometimes affects the outcome of important investigations. So we have some evidence that the revolving door creates problems in enforcement, but I think the more difficult question is what to do about it. So there are already a slew of restrictions on government employees which aim to mitigate these kinds of revolving door conflicts. Probably most salient is the conflict of interest statute, a criminal statute that restricts post-employment activities of federal employees. And Section 207C of the conflict statute imposes a one-year cooling off period on federal employees, forbidding them from contacting their former agency in a representational capacity for 1 year following the termination of their employment. And this cooling off restriction applies to all federal employees earning more than a specified level of pay, which for 2010 was $155,000. But interestingly, after some pay parity reforms raised the pay for SEC staff, which qualified them for these restrictions, the Office of Government Ethics waived the post-employment rules for all SEC employees below the associate director level. So critics of the revolving door insist that these restrictions don't go far enough, and they advocate for reforms to expand the limits on post-employment activities of agency employees. And so Senator Grassley, for example, proposed an amendment to the Dodd-Frank Act, which would have forbidden federal employees of financial agencies from contacting their former agencies for 2 years. And although Grassley's amendment failed, the Congress did include a provision in Dodd-Frank that requires the GAO to study the revolving door conflicts and report back to Congress within a year. My research suggests that this traditional approach to the revolving door problem doesn't really address many of the concerns that have been raised by recent investigations. Absent a lifetime ban on practice before the commission, securities lawyers will be able to exert influence long after the cooling off period expires. In fact, the longer a lawyer spends in private practice representing important parties, I would think the greater the influence that they're likely to yield within the SEC. This type of influence arises not only because of SEC experience, but also accrues to many attorneys who never worked for the agency. After all, Eric Dinallo and Mary Jo White, who were key players in the Pequot matter, were not SEC lawyers, and officials returned their calls because of their positions and their names, even though they had never worked for the agency. So I think that instead of adopting more rules, or more restrictive rules, on post-employment conduct of SEC employees, we should regulate more closely the actions of the SEC's current employees, meaning the SEC should adopt formal rules that restrict external communications by senior staff on ongoing matters, and these rules should be mandatory, with reports of violations subject to independent investigation. So after the Aguirre investigations, the SEC did adopt a new policy which governs external communications, and under these best practice guidelines, senior officials are encouraged to include other staff members when engaging in material communications. The guidelines provide that although officials are encouraged to include other staff members, there are circumstances in which the staff members won't be available when the outside person calls, and therefore the guidelines urge the senior official to balance a number of factors in determining whether to entertain the communication. So I think there are a whole host of problems that will prevent these guidelines from from effectively addressing the special access problem. First, they're merely guidelines that no one's required to follow. They're riddled with loopholes that allow senior officials to continue current practices while remaining in compliance with the rules. And finally, I think they leave too much discretion in the hands of the senior official, and they're unreasonably relying on those who are most vulnerable to outside influence to resist these external inquiries. So the guidelines, I think, fail to provide structural support to empower officials to decline to respond to these types of requests from outside counsel. A better policy would be to adopt the spirit of the guidelines as official conduct standards to which all enforcement attorneys must adhere. The standard should require staff decisions to be appealed through a chain of command, with calls to senior staff coming only after attempts to resolve issues with the line officers have failed. And one advantage of this approach over traditional regulations is that it avoids imposing further restrictions on post-employment opportunities. It focuses more properly on internal rules for those within the agency's control instead of attempting to regulate the conduct of former staffers. Such rules should also empower senior officials to resist outside parties' attempts to influence them, because they can cite these rules when they decline to discuss pending matters and avoid alienating their friends, their former colleagues, or prospective employees. And finally, staff attorneys should feel better supported when they're kept in the loop when key decisions are made. And this should improve morale within the division, which has been languishing for years. So I welcome comments and suggestions as I'm at the beginning of the process of analyzing these problems, and I'm especially interested in hearing from the perspectives of current and former SEC employees on this issue.
Amazingly, we're really on time. Our next speaker, last speaker for the panel, is Paul Mahoney, who's the Dean of the University of Virginia Law School, where he is also, and I love this, A. David and Mary Harrison Distinguished Professor.
We have more than one.
We have more than one. And the Arnold H. Leon Professor of Law. A graduate of MIT and Yale Law School, Dean Mahoney joined the law school faculty after clerking for Judge Ralph K. Winter, Jr. of the U.S. Court of Appeals for Second Circuit, and then for Justice Thurgood Marshall, following which he practiced for 4 years at Sullivan and Cromwell. He's been a visiting professor at the University of Chicago, University of Southern California, the University of Toronto, and his teaching and research areas are securities regulation, law and economic development, corporate finance, financial derivatives, and contracts. He has a strong interest in economics, having served as an associate editor of the Journal of Economic Perspectives and as a director of the American Law and Economics Association. And he will be speaking about some of the aspects of Dodd-Frank and its effectiveness in dealing with too big to fail.
Thank you. And George, thank you for inviting me. It's a pleasure to be here. David actually set the stage very nicely for what I'm going to discuss by noting that there are two different ways to try to make sense of the behavior of financial institutions in the years leading up to the 2007-2008 financial crisis. One is to say that the problem was fundamentally faulty risk management, which led these institutions to fail to appreciate the amount of counterparty risk that they had taken on, to become excessively leveraged, and generally also to fail to appreciate the consequences of a decline in residential real estate prices. The other way of trying to explain their behavior is to say that there was a problem of pervasive moral hazard stemming from the privatization of gains and socialization of losses in the financial sector. And like Jack, I think this is not just a problem for banking regulators. In fact, Dodd-Frank seems to be designed to spread the problem into the securities and derivatives markets, and that's what I want to talk about. First, some background. I think a useful starting point for a discussion of moral hazard in the U.S. markets is October 19, 1987, when the U.S. equity markets suffered a one-day decline of about 20%. Now, the Fed at that point had a brand new chairman, a guy named Alan Greenspan, and he reacted quite decisively to this. The next day, he declared that the Fed would provide as much liquidity as needed to financial institutions. And the Fed funds rate intraday dropped over 1% and then ended the day about 0.5% under where it had been in response to the Fed's accompanying open market operations. And the Fed really got a lot of credit for that incident and was regarded as having prevented a more general meltdown in the financial system. It is, though, worth noting that conditions outside the equity markets would not have, under the standard playbook, called for a loosening of credit at that point. Indeed, quite the contrary. Inflation was running at about an annualized 4% rate. GDP growth had been positive for every quarter for the last several years, although it was slowing somewhat. The value of the dollar was declining against other currencies. And most observers assumed that the Fed's next move was going to be to tighten. Indeed, that may have contributed to the gradual decline in the equity markets in the week prior to October 19. So the Fed's actions could really only be understood as a move to protect the financial system as opposed to the dollar. And a trader carefully pondering the consequences of that might well have concluded that the Fed had decided that its job included reducing volatility in the equity markets. And it was quite clear that some traders did reach that conclusion. They were shortly speaking of the Greenspan put as a phrase expressing the notion that the Fed would act when necessary to reduce the downside risk of equity market exposure. Moral hazard grew with the Fed-engineered rescue of long-term capital management in 1998. That was an interesting year because it started with a decline in residential real estate prices and ended with a sharp repricing of risk in the credit markets, a general deleveraging by financial institutions, and a strong flight to liquidity. Sounds quite a bit like 2007, 2008 if you think about it. And like a number of financial institutions in the latter period, long-term capital management had taken a number of very highly leveraged positions, and those plummeted in value as the spreads between risky assets and treasuries widened quite substantially at the end of that year. The Fed brokered a capital infusion by major commercial and investment banks to keep long-term capital management out of bankruptcy. On one level, this was a quite surprising move for a bank regulator to take. Long-term capital management, obviously, was a hedge fund. It didn't hold current accounts. It didn't do any business with consumers. The Fed, though, was concerned about systemic risk. It worried that the failure of a financial institution to which many other financial institutions, including depository institutions, had substantial exposures, would create a severe overall crisis in the financial system. Now, obviously, we can't know what would have happened in the counterfactual world in which the Fed just said, you're a hedge fund, you made your bed, you'll have to lie in it, and let long-term capital management be resolved through bankruptcy. I think we can, though, say with a high degree of confidence that the incident further persuaded market participants that the government would intervene to prevent the failure of any large and interconnected financial institution, whether it was a depository institution, investment bank, hedge fund, you name it. So let's fast forward to the 2007-2008 financial crisis and the Dodd-Frank Act. As we know, of course, several non-bank financial institutions were bailed out in the aftermath of the crisis because of a concern about systemic risk. Perhaps the most controversial of those was AIG. The case for those bailouts centered on systemic risk. The case for systemic risk centered on interconnectedness. And the case for interconnectedness in significant measure was based on derivatives contracts. AIG in particular was a very large seller of credit protection through credit default swaps. Other commercial and investment banks had substantial exposures to mortgage-related derivatives. And accordingly, one of the animating ideas behind Dodd-Frank is to reduce systemic risk associated with derivatives transactions by forcing many over-the-counter derivatives onto regulated clearinghouses, and therefore bringing them into the SEC's and CFTC's regulatory orbits. The underlying idea is this: over-the-counter derivatives leave the parties exposed to one another's credit. When the flight away from risk and toward liquidity began, the credit quality of many large over-the-counter derivatives dealers, such as Lehman Brothers, Citigroup, Goldman Sachs, AIG, etc., began to deteriorate rapidly as well, and that deterioration spread to their counterparties with the realization that the dealers themselves may not be able to meet their obligations. The solution to the problem embodied in Dodd-Frank is greater reliance on centralized clearing. A clearinghouse or central counterparty steps into the middle of a trade and acts as counterparty to each side of the trade. That is to say, the buyer and the seller of a derivatives contract each look to the counterparty, the clearinghouse rather than the initial counterparty for performance. The clearinghouse's net market exposure is always zero because it's on the opposite sides of every trade, but it is, of course, subject to credit risk from its members. It mitigates that risk, first, by limiting membership to well-capitalized clearing brokers. Second, by requiring margin, by requiring effectively a deposit of collateral for each trade. And third, by being well-capitalized itself. Now, my concern in all this is that the solution may not be as real as it appears. I want to put to one side a separate issue, which is transparency. The central clearing, along with the reporting of all trades, may in fact increase transparency, and that may be independently a good thing. But I think the idea that it is going to do away with systemic risk is oversold. Let's start with the obvious point. Clearinghouses themselves will be too big to fail. Every financial market participant, I believe, will assume that the government will not allow them to fail, so they will operate with an implicit government guarantee. Now, the supporters of the central clearing idea tell us that that won't, in fact, be a problem because regulators and simple self-interest will require the clearinghouses to have very robust margin rules, and so they will not, in fact, fail. That strikes me as quite unrealistic. Let's, again, explore the underlying incentives. When parties A and B enter into a swap transaction or other over-the-counter derivatives transaction, each is exposed to the other's credit. Each, in principle, protects itself against that credit risk by requiring collateral or some other form of credit support. In practice, what we observed was that the large swap dealers, such as the Goldman Sachs, AIGs, and Citigroups of the world, required collateral from their counterparties who were not themselves large swap dealers, but rarely put up any themselves. A nominal justification was that the large swap dealers were not themselves very risky. Either, like AIG Financial Products, they had a guarantee from a AAA-rated parent, or like Lehman Brothers Derivatives, they were a bankruptcy remote subsidiary that itself had a AAA rating. Now, it is true that in many cases the agreements required the dealer to post collateral if its own rating or the rating of its parent dropped below AAA. Now, however soothing that may have been to in-house counsel who could then go to their bosses and say, I've thought of everything, In practice, obviously, that is going to shut the door after the horse has fled. That was certainly the experience in 2008 when AIG, for example, was downgraded and faced calls for additional collateral. It did not at that point have sufficient liquid assets to satisfy those calls. So again, we get back to the question, why did some very smart people enter into over-the-counter derivatives transactions with Bear Stearns, Lehman, AIG, and others who would in fact be exposed to significant risk in a more generalized credit crunch? Again, the comforting answer is that it's just all poor risk management. Investors were lulled into a false sense of complacency by their computer models, and Dodd-Frank will protect us against that in the future by making regulators pay more attention to systemic risk and requiring more capital. The explanation that I find more persuasive is that traders believed that the government would simply not let a large and interconnected financial institution fail, so there was simply no need for expensive and administratively complicated forms of credit protection. I think that final point is worth just a minute's worth of elaboration. I suspect that some credit default swaps in particular may not have made economic sense if it had been up to the parties themselves rather than the taxpayers to bear the tail risk of that transaction. And I think that has implications for what might happen when those transactions are cleared centrally. A credit default swap faces a problem known as jump risk, which is to say that the credit seller's obligation is to pay the buyer's entire loss up to the notional principal of the transaction when there is a defined credit event and zero otherwise. Now, the likelihood of a triggering event occurring is obviously much higher when there's a general decline in the credit markets, and it is quite plausible that what you'll see happen is what in fact did happen, which is simultaneously the creditworthiness of the reference entity declines, the creditworthiness of the credit seller declines, and the price of treasuries, which are the preferred form of collateral, rises, making it very, very hard for the transaction to work as hoped. The net result is that a late demand for variation margin is going to be too late. To provide real credit protection, the initial margin, at least for CDS transactions, will have to be quite high. In fact, I've seen models suggesting that it should be as much as 50% of the notional amount. Now, I just want us to think about what's going to happen when a clearinghouse with a regulator behind them comes up to swap dealers and says, you guys are going to have to start posting whatever, 30%, 40%, 50% initial margin on credit default swap transactions. The dealer is used to posting zero. And the dealer also is not going to be much persuaded by the argument, well, this is just a collective action problem, and when everyone puts up more margin, everyone's going to be safer, because the dealer's view is the taxpayers are the ones who are going to bear the risk if something really blows up, so why should I be putting up a lot of money now? The dealers are going to scream bloody murder. They're going to say that the models are all wrong. They are going to darkly hint that this entire market's going to move offshore if the regulators back down. And I think if history teaches us anything, it's that the dealers are likely to win that argument. It may well be that the drafters of Dodd-Frank actually wanted to shut down the entire credit default swap market on the view that the tail risk is just too great and the government's always going to end up bearing it. But I think it's highly unlikely that that's what that is what in fact is going to happen. So can anything be done about this problem? I think we probably just need to start by recognizing that too big to fail is simply not a demonstrated fact about how markets operate, but an empirical assessment of how governments operate when in panic mode. And of course, from that perspective, the fact that the government panicked on a heretofore unprecedented scale in late 2008 and early 2009 is going to increase moral hazard no matter what we do about it today. So the bad news is that the government will not have a chance to restore its credibility until the next financial crisis. The good news, I think, is that the incredible public anger about bailouts in the last year and a half at least raises, in my view, the probability that the government will decide to restore its credibility the next time we have a financial crisis. Stay tuned.
At this time, I'd like to ask the three of you if there are questions you'd like to pose to one another based on what you've heard from one another, or more generically about the topic.
Well, let me just follow up with what Paul was saying, 'cause Paul makes some very interesting comments, many of which I agree with. I've said elsewhere that I think the single worst case scenario that I can imagine is the failure of a clearinghouse. And I think that prospect is out there. Now, what does Dodd-Frank say about that? There's a wonderful provision in Dodd-Frank that totally denies the Federal Reserve any ability to lend to a clearinghouse. So we're painting ourselves much more into this corner. And you can say, well, the country's got to learn, and we'll have to have the cure of moral hazard, we'll have to have the failure of a clearinghouse. I think if we have the failure of a clearinghouse, we will be living in financial ruins and will be bound down to financial cave dwellers for a period of time. So I don't think we want to test moral hazard there. I would point out, however, that the one thing left out of your story is the government did let Lehman Brothers fail, and Lehman Brothers might have been the maximum failure that our economy could have withstood. I don't think we could have easily accepted the failure of AIG without a global financial system having a huge crisis. But Lehman, we survived. If you talk to the New York lawyers of my acquaintance, they all think it was a terrible mistake. It was a mistake in terms of their self-interest, because it really did have an impact on the New York financial sector. But I think there was a case for letting Lehman Brothers fail, and I think it does make it a little less easy to say in the future that they'll always bail out a large institution. Clearinghouses, however, I think we have a massive problem. And I think, let's put it this way, as you were correctly saying, it's going to be hard to raise margins. Moreover, clearinghouses are essentially run by all of the members in the trading industry. And they know that higher margins, in their view, throw sand into the gears and make for a lot less trading and a lot less profit. Therefore, I think they're going to understate the risk in their mutual self-interest, hoping the government will bail it out. So we'll probably have inadequate margin levels at clearinghouses. The prospect of failure will be compounded by the Fed having its hands tied, and we will have a massive crisis. The same thing we had in 2008, when Congress wouldn't pass the TARP bill, and suddenly the stock market fell 500 points, at which point stock-holding constituents started telling their congressmen they changed their minds and they did want the TARP bailout. But it may take another 1,000-point or so decline in the market before we're able even to deal with the clearinghouse failure. I talked about the regulatory sine curve. The regulatory sine curve is definitely going to be at play in this area because all the regulations will have so low visibility. You can't explain a credit default swap to most people out there on the street. So these regulations will be intensely lobbied, and the incentives of the clearinghouse owners will be to have limited regulation. So I do think this is a problem without an easy solution.
Well, that final point is one I completely endorse. So the failure of Lehman Brothers is something that we could spend the rest of the day obviously talking about that. It is an interesting part of the story. A couple of fascinating things about it. One is, of course, the financial sector lawyers in New York thought it was terrible. The bankruptcy lawyers in New York loved it, the failure to bail out Lehman Brothers.
They are vultures, of course.
It was, and again, this is something we could spend all day on, which is how much, how difficult was it, in fact, to resolve Lehman Brothers and to resolve those trades? Most folks that I talk to say much less difficult than people believed up front. There's also just the truly fascinating fact that if you look at the spreads between risky assets and treasuries in the credit markets, they don't explode right after the government announces Lehman Brothers is not going to fail. They explode.
Is going to fail.
It is going to fail, excuse me. Isn't going to be bailed out. They explode when TARP is announced. Now, that's probably informational. It is effectively a reaction to a statement of government belief that the problem is much worse than anyone's giving it credit for. But what's interesting is that they don't explode immediately after the Lehman Brothers failure. So if you're asking me, would I settle for a split the baby proposition in which clearinghouses get bailed out and no one else, well, yeah, that's better than everybody gets bailed out, I think, without a doubt. Would the failure of a clearinghouse turn us into financial cave dwellers? I will just express my skepticism on that.
Be an interesting experiment, but a costly one to find out.
Very costly one. And please do it with someone else's money.
Someone else's economy.
Yeah. How about Iceland?
They tried it.
I'm going to ask you a question, Professor Coffey. You mentioned in your presentation the concept that we want to have a layer of contingent equity coming from the credit side, the debt holder side, to offset some of the tendencies of common stockholders to cause management to take greater risk in times of pending insolvency. Are there other circumstances where other constituents of a corporation might also appropriately have voting rights?
Well, I mentioned quickly but didn't defend the idea that voting rights are normally given to the residual risk bearers. If you give voting rights to bondholders generally, let me point out that I believe it's only Delaware that authorizes in its corporate law that bondholders can have voting rights. And while they permit it, it's almost never done because voting rights in the hands of bondholders, a bondholder has a rational desire to resist any additional debt issuance after the time he makes his investment, because if there's further increase in risk, he doesn't share in the upside gain, he shares in the downside loss. That means that a bondholder-dominated firm would decline a number of net positive value investments that a shareholder-dominated firm would accept. That's a cost to efficiency. But I think that once we get closer to the problem area, creating preferred shareholders who don't have exactly the same incentives as bondholders but have very different incentives than equity shareholders may be a way to give management some buffer for their own preferences. Management doesn't have the same preferences as shareholders, which is why we have elaborate executive compensation. So I'm telling you generally, I'm nervous about giving every group out there voting rights in the corporation. I think they can deal with contracts, union negotiations, and other mechanisms.
In fact, I was specifically thinking of the union situation, which is why doesn't a union demand a change of control vote, for example? Before a company can be sold, you have to get our approval. After all, it's our jobs that are going to go to China.
I was visited by a professor from the University of Hong Kong day before yesterday, Wednesday, who says that the Chinese corporate governance law is under great pressure because there's a lot of new demands from shareholders, and they still maintain, at least in theory, that it's a workers' paradise in China. But there have been major layoffs and there have been major incidents about worker suicides, and they are talking about giving, of all people, not only the unions but also the environmentalists a seat on the board. And I have suggested to them I don't think that's a long-term corporate governance solution. There might be other ways of dealing with the need for greater environmental protections.
Right. It was interesting to observe that there's over 30 states that permit the board to consider the interests of other constituents. And there's one state that requires it, which is fascinating. I mean, I don't know if any corporations are incorporated in Connecticut, but they are required. to.
But this was all takeover protection. There was only one reason for this.
It was originally takeover protection, but it certainly could be expanded in response to the growing shareholder movement pressure.
We can give directors any norm we want, but if they're elected by shareholders, they will respond mainly to the interests of shareholders.
They will respond, certainly. And the question is, who is a shareholder today? Is it a person who buys today and sells tomorrow? Is it someone who's bought and hold? Those are questions that the states have to be dealing with. No state has dealt with the issue.
I think we could see developments in Asia where we might see the board of directors being parceled out between different constituencies.
I'd like to ask Professor Jones, isn't the problem you're describing, the revolving door thing, simply a matter of humanity, basic human social relationships? How can you ever regulate or stop the advantage of someone who used to work at a place or used to work in that field from having an edge over the person who doesn't? You know, my former partner, Charlie Carberry, was a prosecutor in the Southern District. I assure you, he has better chances of dealing with a enforcement agency than I do.
Mm-hmm.
That's just human.
Right. So, I mean, one way of putting that criticism is that, powerful people have power. So what's the surprise about that? And I agree that that's true. But, knowing that powerful people have power, I guess the question is, what to do about it, to protect the integrity of the investigatory process. And I think one thing you can do about it is not make it easier for them to wield their power, but make it more difficult, and also just being mindful of, from a management perspective, what are good management practices. And I'm not sure it's a good management practice to facilitate outside attorneys sort of undermining the authority of the staff attorney, or a good management practice for the director of the SEC to be fielding these types of the SEC enforcement to be fielding these types of phone calls. So I'm trying to think of procedures or internal controls that acknowledge the fact that powerful people have power and try to normalize or regularize the way they influence power so that the playing field is more level.
I suggested to you last night at dinner that sometimes the true power is not the lawyer at the other end of the phone call.
Mm-hmm.
It is the congressman who might call the chairman of the SEC,
Right.
Who may have been their former colleague, during some periods.
Right.
What do you think about the top-down kind of pressure? I mean, no staffer is going to.
Well, I think any kind of, I don't know what you would call it, improper influence is problematic, and I think we can't stop all of it, but we can have rules that seek to discourage and control it, and we can have a process where there are indications that this is going on, there's a way for finding out what's really happening and doing something about it.
I think it.
Can I add one
Yes.
footnote to this? Because I applaud the kind of research that Renee is doing. I think it's very interesting. It's sensitive, and you got to avoid sweeping conclusions. But there's another kind of research that might be done in this area. The SEC has been going through an amazing transformation in its enforcement division, a kind of regulatory reorganization that follows everything that business schools have been talking about for 30 years. If you read the business school organizational literature, they talk about flattening organizations. Organizational design. And the SEC, under its new head of enforcement, has engaged in a significant effort towards flattening and removing intermediate layers. It would be very interesting to try to study what impact that has on outcome. Do we see greater efficiency? Do we see changes? I think we will see cases processed more quickly. I think we'll see cases less likely to be stopped in intermediate layers, but I think that's the kind of study that should be followed up on, because it is a change in organizational design, and what follows from that is a very open question.
Right.
Okay, at this point, I'd like to open it up to the audience. Yes? Let's wait for the microphones to come down. If you have a question, put up your hand, I'll call, but I will designate someone to give you a microphone.
Yeah, my question is about the revolving door issue. So I know that you focused on enforcement, but I wonder what the implications are for the regulatory side, in particular the public choice critique that sometimes agencies like to regulate at the behest of large businesses to help make their competitive position much better against other smaller businesses, or that lawyers like to regulate. Lawyers love regulators because it gives them a lot more
Right.
advisory business.
Right.
And so the commission might promulgate onerous regulatory, rules solely out of that sort of public choice dynamic.
Right, so the more complicated the rules are, the more valuable lawyer services are. So, I mean, the idea there is that when you're at the SEC, you make lots of complicated rules, and then when you leave the SEC, you help people to deal with the rules. And
Law professors and their students like this.
and it's I think it's plausible. I'm not sure that's exactly what's going on, but I guess it's just a whole different type of problem than the problem that I'm looking at. But I think there's something to that story as well.
Let me follow up on that and extend, I think, what David's point was. I think as you further this research, you ought to keep in mind the possibility that these communications are two-way, and that a senior official at the SEC uses these people too,
Right.
as sources of information, sources of influence. And there's an element of reciprocity here. You need your networks because you have to reach out sometimes. If Morgan Stanley is recruiting a new CEO, actually the SEC needs to know what's going on there. And it may be through, whether it's Mary Jo White or whomever, these conversations can be extremely useful to the SEC and the SEC staff. And I wouldn't want to shut down the one-way direction if it would result in a substantially diminished quality of information in the other direction.
I'd add to that with respect to the two-way conversation, the inside enforcer or regulator has to make a judgment call about the importance of situation. If it's Morgan Stanley, which is a very large organization important to the financial integrity of or the integrity of our financial markets, asking whether they're going to hire someone who might be tainted, isn't it in the market's greater interest for that answer to be known earlier rather than later? If they go dark and say nothing, then we either have an organization deprived of a leader because the corporation says, then I can't touch this guy, he's radioactive. Or if they give the right body language or response, they say, yeah, okay, we can do this. When does the regulator have to make an assessment? Isn't a judgment call of the regulator to make some of those kind of assessments? And yeah, it gives rise to problems, but do we want to cut it off? I mean, which is better, silence or giving out a leak?
I guess that's a very complicated question. I guess, my approach is that Morgan Stanley's decision to hire its CEO is Morgan Stanley's problem. And that at the point the inquiries came in, I don't think anybody knew for sure where that investigation was going. So it was, a judgment call that then actually changed the direction of the investigation, which is what I thought was
Yes.
problematic.
And the judgment call that may have been wrong was to give that information. Yeah. If it were.
Well, I'm saying it seems to. I'm not saying that it did. I'm saying that from the way that things were going to the way they ended up going, it seemed like there was a shift.
Yes.
Sure.
Would you like to? No, he'll get there. Next panel. Okay, another question? No. Yes.
Thank you. This is a question for Professor Coffey. In your conditional capital system, do you see a process that would unwind the conversion where they would go back to being a bondholder?
Yeah, I didn't get to that in 10 slides, but I think a major financial regulator should have a say before you get to redeem or buy back this entire class of stock. But I do think at some point you can redeem preferred stock, you can call it, you can just buy it in the market. They'll sell that at a price. So I think the question is, how quickly can you do it so that we don't have a quick resort to the same increased leverage? But we're only talking about this in the case of systemically significant institutions, and I would assume that a major change in capital structure, such as retiring the preferred stock, would require the approval of the principal financial regulator.
Jack, you explained, you've talked about, in a sense, the tyranny of shareholders. I'm wondering, what governance are you advocating for corporations? Because you seem to be saying that if you give shareholders too much say, that's bad for the corporation. But what's the
I'm not talking about
alternative?
corporate governance generally. I'm starting with the idea that systemically significant banks are different because there's a huge externality, as 2008 proved, and if we had AIG go into failure, which is another shadow bank, we'd have an even greater problem. So I think in the area where there's this huge overhanging externality of a too big to fail or a too interconnected to fail financial institution, we have to think about this. We're already talking about contingent capital, and no one's focused on the idea that when you shift from debt to equity, there are also voting rights involved, and I want to put them to use. But I agree, I don't want to give voting rights to bondholders generally or to preferred stockholders generally, and I do think that at a point after the crisis has passed, the corporation could redeem this debt and go back to common shareholder-dominated firms.
Well, it seems to me what you're also saying is that particularly for systemically important institutions, you do need enhanced oversight and regulation, the external, I mean, that is
Sure.
the class.
Oh, I'm all for
to
enhanced,
have
my point is
regulation.
enhanced oversight really won't solve all problems
Right.
because they'll sneak under the radar screen. And I'm trying to deal with what do we do ex post, because there always will be these problems ex post, and I'm trying to break the crisis by using contingent capital to avoid that default that triggers a panic.
Question up here.
This is for Professor Coffey or Mahoney. Rather than instituting an advanced or a new regulatory scheme, what about increasing disclosure? Because a lot of the activities done in the derivatives markets were done behind the veil of secrecy. They weren't available to the public. What about just increasing the disclosure requirements so that all of these activities can be seen by the market, so that they don't sneak up upon us, so that we can react sooner rather than later?
I think many of us are all for saluting transparency. Whenever you run up the flagpole, I will salute, but I don't think it's a complete answer. We have a problem with the likelihood of systemic failure, and one way to avert that kind of panicky experience that triggers it from Drexel Burnham through Bear Stearns, we've seen that same flight of the short-term creditors when they panic, and I think one way of dealing with that is by having this idea of contingent capital. We could also have the bank tax. I'm not opposed to the bank tax, but that's really dealing with a moral hazard problem that the debt security is too cheaply priced. I'm trying to deal with also what I think is the shareholder side of this. Just as shareholders won't resist pollution if it's profitable, I think shareholders won't resist other externalities if they are profitable.
Yeah. So I think, again, I put the transparency issue to one side in my talk. I think one thing that is really quite beneficial about a clearinghouse is that all counterparties will suffer the same loss proportionately if the clearinghouse goes under. So if I hold a particular type of derivative contract, a particular position, whether I suffer a large or a small loss is not going to be dependent on, well, is my counterparty Goldman Sachs or Lehman Brothers? It's only going to be dependent on what resources the clearinghouse has. And that's probably on the whole a good thing. Like all other good things, it's a question of what does it cost and is it better enough to be worth the cost. One thing that I think it is possible to overestimate the transparency problem in 2008. My understanding from talking to hedge fund and other investment banking people, right after the decision to let Lehman Brothers go into bankruptcy, was that institutions knew all too well what their exposures were to different financial institutions. Now, it may well be that their shareholders weren't completely informed about what those exposures were, and it may not, and the regulators may not have been completely up to date on what those exposures were. But interestingly, there was a mad scramble around the derivatives market in that next week as people tried to reduce their exposures to institutions that they thought previously were simply not going to be allowed to fail, but that they now realized, oh my gosh, maybe the government really would let Goldman Sachs go under, so maybe I better start reducing my exposure there. So I don't think I don't think it's accurate to say everyone was sort of in the dark.
I will say that one problem with derivatives is that if you mention the word in front of a lot of people, their eyes glaze over because they don't understand them to begin with. And so no matter how much information you put out about specific transactions, they don't understand the basic concept. It's not a simple one.
Well, you know, one point on this, we've talked about derivatives, but the government also intervened very quietly and effectively to prevent the money market funds from breaking the buck. The public does understand that. The public would have been panicky very much if Fidelity and Vanguard had broken the buck. It would have hit the American consumer very hard. There's another area where we have a too big to fail quiet policy, and it's not simply this very non-transparent world of derivatives. Okay.
Question for Jack Coffey, although the other panelists might want to comment. I think your proposal's a good one, Jack, although its effectiveness might depend on the details, such as setting the triggers at the right levels. An opinion piece in the Times this morning says the problem is that in days of yore, the partners of the investment banking firms were personally liable, and now they're not, and suggests that what we need to do is to require that these firms have a certain number of members, partners, whatever they would be labeled, who are personally liable. Or somewhat less extreme, it has generally been suggested by some commentators that the limited liability in all areas invites a certain degree of moral hazard. On the other hand, unlimited liability poses the threat of personal ruin, and have suggested, therefore, the idea of proportional liability. Is that something that ought to be explored? Either one of those.
I don't have a complete roadmap to give you a full position on that. It is interesting to note that the investment banking firm that did the best in this crisis was probably Goldman Sachs, and that's probably the firm that still had the largest partnership culture and still had partners running the firm in a way. So there is a difference in behavior between the corporate investment bank and the more partnership-oriented investment bank. That doesn't mean to me that I am ready to encourage personal liability. I think that I believe in personal liability, but I believe it in enforcement actions. I think the SEC, as we could have been discussing the Bank of America case today too, that's an area where I think the Commission is going to have to recognize the need to move increasingly towards individualized liability and not just imposing penalties on large corporate entities. A whole different topic, but.
Right.
Well, I would just say that the traditional investment banks just did not take on risk in anything like the way that a modern corporate investment bank does. So it's really, in some sense, a policy decision about, do you think the investment banking world of the 1950s and 60s was better than the investment banking world of today? And I think one could again find costs and benefits on both sides. But I don't think it is likely that you can have an investment bank structured the way they are today with people who are personally liable, who are going to say, look, I can be wiped out for reasons that have nothing to do with my lack of effort, bad behavior, et cetera, and I'm not signing up for that.
I think we have time for one more question. This gentleman.
Professor Coffey, you said that one of the leading causes of this problem was pressure from shareholders with respect to compensation and things like that, so more risk would be taken. Are there not some groups of shareholders that are countervailing pressure, like large state pension plans, CalPERS, for example? And how do they interact with the other shareholders who are bringing this pressure, and are they just overwhelmed? Is that the problem?
Well, this could be an hour discussion. It's a very good question, but I would say that we look at shareholder pressure today. It's probably the proxy activist who leads that, whether it's risk metrics or the old ISS. I think that's where we find pressure is focused, and it's also the hedge funds, because they are going to be the initiators, and they may knit together a constituency. Again, I'm not trying to say shareholder pressure is bad across the board. I have no problem with Carl Icahn trying to get on the board of Lionsgate. I have a problem with Carl Icahn on the board of Citigroup. That's a difference. But in terms of pressure, I think shareholders, the index shareholder, I think, tends to vote today as the proxy advisor instructs them. A generalization, but that's all I can give you.
It's a generalization that has been true for several years, and if you go and look at the webcast for the last Leet Institute, you will see hours of discussion about that subject. So that was a major focus of some of the talks 2 years ago. We have come to the end of our time, our panel's time. I want to thank our guest speakers. I think it's been tremendous. And we will now take a 14-minute break. We'll start promptly at 11 o'clock.